Get rolling here. Welcome everybody. Thank you so much for joining us for this month's industry update. Super excited for our guest speaker today. Before I introduce Rob, I wanted to let everybody know to save the date for our November update. So November 5th at 2 p.m. we're going to have Deanne Stodden, who is an attorney who represents banks and lenders, mortgage servicers. She's going to be on talking about forbearances and foreclosures, and we're going to be looking at what we're predicting for the foreclosure market here in Colorado. So save the date for that. And again, big thank you and welcome to Rob Cohen. Rob is an attorney and managing partner of Cohen & Cohen and specializes in bankruptcy. And he is going to share with us today some of the trends that he's seeing with regards to BKs and just the impact that they can have on real estate transactions. So, and of course, we've got our usual suspect here on the panel as well. Damian Cox is joining us. He's going to give us also a brief update on COVID as it pertains to real estate and some happenings as well. So thanks again for joining. We love your questions. Please put those in the Q&A and we'll address as many as we possibly can. So with that, I'll let you two take it away.
All right, well, I'm going to get out of the way and just do my stuff real quick, Rob. That's all right with you, just to get a, and then we'll let you just take it away from there. But I'll tell you, there's not much to update as far as COVID-19 and governor orders are concerned. There was a new order released September 15th. The new order is, I think, 1 million pages long. It talks about safer at home dial. So what this is that the safer at home program or safer at home requirements that we've seen for months now are essentially the same, except for they've now changed it into levels. There's now different levels 1, 2, and 3 that are available for, depending on how many cases, how many hospital beds are available, all this as far as which level you fall into. For real estate, it didn't change anything. You still have indoor event qualifier for open houses. You still have your requirements for showings that we've always seen. Still have requirements to try and minimize contact, wear masks. Everything in the offices is all the same. What this really is for is outdoor events and indoor events as far as number of people that can be in attendance. But the one thing that was nice that came out of this order is that there's now an interactive map on the governor's website or public health CDPHE's website. And Jill, would you share that with everyone real quick? So here is a link to the website, and you can see it has 5 different levels. Stay at home is obviously what we were under in March. Safer level 3, level 2, and level 1 are under this new order. And then the green is protect our neighbors, which as of last time that we were talking, nobody had been able to get to. We now see that there are 5 counties that are now under protect our neighbors. So for those of you working in different counties, this at least tells you what level each of these counties is on as far as what they can and can't do. Jill's going to send out a copy of the Public Health Order 2035 that talks about this dial-up order, as well as a link to this interactive map so that you guys can see in real time what's happening in each of your counties and what the new requirements are. But as far as real estate's concerned, guys, it didn't change anything for you. All the requirements you had in your offices, in your offices, in your showings, in your open houses, or whatever else, really is the same. This is really for some of the other industries that were impacted about trying to loosen some things for them, depending on the level. The last thing I want to mention is this: is that a lot of people are starting to look at classes. I've had questions about a contracts update class for this year. I will tell you guys, I'm not going to do a contracts update because not many contracts changed. The post-closing occupancy agreement changed. That's really the one that impacts you guys. And then they created manufactured home forms. And if you are not doing manufactured homes, I just don't see the point in doing a contracts course. You can pick it up, and I'm going to have Pitfalls, which is going to talk about some of the changes that were made. ACU in 2021 will talk about the changes as well. If you are doing manufactured homes, you probably need to take a class specific to manufactured homes and contracts. And we'll be creating one of those later on in the year so that if you do manufactured homes, you can get some training on what that form looks like. So that is all I have for updates. And so with that, Rob, let's talk about what everybody wants to hear about, which is bankruptcy.
Yeah, no, I'm happy to chat. And so by way of introduction, I think everyone probably knows you guys. So I'm a attorney here in Denver Metro. I've been practicing law since 2003. Been a bankruptcy attorney most of that time. I also serve as a Chapter 7 trustee. And so to the extent that you know what that is, that's the guy who sells the debtor's stuff. So I represent debtors and I do trustee work. My trustee stuff is primarily in Southern Colorado though. So pretty much the southeastern section of Colorado. So I don't do any debtor or creditor work down there just to make sure that there's no conflicts of interests. But I do all my debtor creditor work up here. Let's see. I really want to have an open dialogue today. I mean, me sitting up here monologuing the whole time is just like not okay for some reasons. And so please, jump in, Damian or Jill, if like, stuff comes up. And then as much audience participation as possible is great. So please, I don't know how I mean, this is really my first Zoom kind of presentation thing, so I'm sort of new at this. So raise the hands and do whatever it is that you have to do on Zoom. Let's see. And then as far as the agenda goes, I think what I'm going to talk about is a little about bankruptcy statistics and what we expect to happen in the bankruptcy market. And then, it was advertised that we're going to talk about dealing with the seller and buyer in bankruptcy. And that's just kind of what I'm going to go over. I'm going to go over the most common things that I see on a regular basis with that stuff. And so I'm going to try to share my screen. Oh, before I do that, if anyone ever has a bankruptcy issue, I mean, you're always welcome to find me and give me a call. I don't know if you have my information. Maybe someone can put up on chat or something. I don't know.
I'll make sure to send it out to everybody after.
Seriously, give me a call because I talk to people all day long. I call people all day long when I need free legal advice. I call Damian from time to time when I need free legal advice on real estate law. And so what goes around comes around. So I'm happy to chat. Let me try to share.
Now, while you're doing that, I like to point out, Rob is not a typical bankruptcy attorney in the fact that there's some bankruptcy mills out there that, pay your money and we'll run it through the process and you may or may not talk to the attorney, and maybe that's oversimplifying it, but at least that's been my experience with some of these. I was going to say turkeys, but that probably isn't the appropriate word. But Rob is one of these bankruptcy attorneys that will work with your clients and talk to them about options, even if bankruptcy isn't the right option. So for those of you that find you have clients that are in a position that they really need to figure out whether or not bankruptcy is right for them, Rob is a good resource.
Great. And I can't share my screen. It says host disabled participant screen sharing.
Willie?
Oh, one moment.
And thanks for the props there, Damian.
Well, you paid pretty well, so
I'm amazing,
You paid well enough. I figured I could do that.
That's right. That's funny.
Try it again.
Oh, there we go. Okay. Okay. So can you see my hit share now? Can you see my screen maybe?
Yeah.
Is it an Excel spreadsheet or whatever?
Yes.
Or graph? Okay.
Yes.
All right. So this is my own internal spreadsheet. I didn't create this for this presentation. This is what I use. And so it's not going to be the prettiest spreadsheet around because it has 10 years of data on there since I've really been tracking it. But fortunately though, it does go in roughly reverse chronological order from top to bottom anyways. And so what this graph represents is the total bankruptcy cases filed in Colorado by year. And so at the very top there, you can see 2010. That was the peak year of bankruptcy filings. What's sort of interesting about this, the whole collapse happened in 07 and 08, but bankruptcy has always been a lagging indicator of the economy. And that was even true back in 2001 in the tech bubble burst. So I didn't start practicing till 03, but we still had guys and people coming in 04, 05 who were the remnants of they lost everything during the tech bubble. And so people tend to hold on for as long as they possibly can until bankruptcy is filed, for better or for worse. There's no judgment, and you do what you got to do kind of thing. And so anyways, the peak was 2010, and then you can sort of see the amounts going then down by year. One other thing I'm sure that most of you have probably already noticed by now by looking at this graph is that there's a massive peak in March. And that's whenever I've shown this graph to anybody, that's like the first thing they laser in on. And that's a sort of interesting peak. And I mean, I don't know that anyone really knows why it peaks in March. I will tell you what the accepted knowledge is that the way bankruptcy works is it's based on when people get their tax refunds back. Because tax refunds in bankruptcy are subject to seizure in most cases by the bankruptcy trustee. And so what you're seeing here, you see that late February, March blip, or that spring bump in bankruptcy filings, is you see people receiving their tax refund, spending it on appropriate things like pre-bankruptcy planning or even just living expenses. You know, we're not talking tens of thousands of dollars. We're talking, $3,000, $4,000, $5,000 of tax refund, and then they file bankruptcy after that money is spent, or they just spend it on their bankruptcy attorney and they call it a day. So that's why you see this blip. What I really don't know is if you look at that October blip, and that's also pretty consistent. And there's no real rationale for why there's an October blip in bankruptcy filings. I don't understand it. It's the oddest thing. And honestly, it's probably, my best guess is that it's probably these people who hire attorneys will wait to file bankruptcy. They won't file in November, December, because those are slow months anyways. But you also will just advise your client to not file bankruptcy until you get your tax refund back. And so this just goes down then. But anyways, that's the data. You can see this year's filings at the very bottom of the chart. I mean, it's down roughly 60% since the peak filings in 2010. You could see that it was starting to sort of like level off the past 2 or 3 years. All those lines, they start to kind of blend together. And so bankruptcies had been steadily declining, obviously, because we're in a massive recovery, particularly in the last 4 years, 4 or 5 years. And so they were starting to level off. And now they went down, which to be honest with you, is kind of a good segue into like, where do we think it's going to go? I mean, the conventional wisdom, I mean, everyone in the bankruptcy bar, all the smart people, they say, bankruptcies are going to skyrocket. I mean, they're just going to blow up. That Zoom call I was just on, people started mentioning bankruptcies are going to skyrocket and they're going to blow up. But you know what? I will tell you that in March, those same people said, oh, by this summer, we're going to be so busy, bankruptcies are going to blow up. Now, I guess they didn't really understand, well, they were wrong, right? But, no one has a crystal ball. They can't see the future. I didn't really, personally, I didn't really think so. And I don't think they're going to blow up as fast as everyone says. And maybe I'm wrong. Because, really, the unemployment that people got when they were unemployed, especially that $600 a week kicker, I think the math was if you made less than 35 or 40 a year, you made more on unemployment. And so the people that were unemployed for the past, 3-4 months actually made more money on unemployment. Likewise, too, like the PPP and the EIDL loans, all that stuff came out. I mean, that was definitely a shotgun approach to, hey, let's just shove a bunch of money in the economy. That has actually really helped out. That's really worked. And then also too, for anyone on the line who's got their own other alternative businesses or has SBA loans, for example, the SBA, they're paying right now. And I don't know when that's going to end, but I know that they're paying the bill for these businesses. And so, you combine the PPP loans along with, the EIDL, the unemployment, and I don't think there's a great short-term immediate need for the bankruptcies. Now, like I said, bankruptcy is absolutely a lagging indicator. And right now, we're getting the people who are coming in, particularly the people who are like higher income, whose jobs were a bit iffy, like a lot of contract workers, like, project managers who just did very like consulting type gigs who did very well and were living within their means, and now all of a sudden they're working at Target. I mean, that's like a client I filed just the other day kind of thing. She was doing just fine. She had a bunch of credit card debt, but now she's nowhere close to being able to pay that debt now. In the future, I absolutely think that we're going to pick back up. Where do we go? I don't know, but it's going to increase. I think we're going to see a lot of Chapter 11s, a lot of businesses filing bankruptcy, because really,
Hey, Rob, would you do me a favor and tell the difference between the chapters just really quickly? Because some people may not know, 13, 11, 7.
yeah, no, that's a fair point. So the Chapter 11 bankruptcies, those are typically like the business reorganizations, as opposed to a Chapter 7, which a business can do. That's when a business is just shut down. It's a business liquidation. But most consumers, individuals, do a Chapter 7. But businesses will do Chapter 11s. And Chapter 11s are a very effective tool to restructure debt, lower monthly payments, and things like that. And I mean, I'm already doing some for restaurants. I mean, a lot of these COVID impacted businesses, who is COVID impacted? But like the ones like gyms and restaurants and things like that. So we're already getting some of those coming in. But yeah, so a Chapter 11 is a business reorg. A Chapter 13 is a consumer reorganization. So basically, if you make too much money to do a Chapter 7, you end up doing a Chapter 13. And then the Chapter 7 is by far the most common file of bankruptcy in Colorado. And then to digress a little bit, I'm gonna stop the share. Do we have any questions on this before I go on, or is that a sufficient prediction, you think, Damian, of it's going to go
No,
up?
I mean, it's interesting that you got this showing it was way down, but I think you're right. I mean, a lot of the money they put into the economy probably shifted bankruptcies that would have otherwise potentially been filed. So it's very interesting. But yeah, go ahead and unshare. And
all right, I'm going to unshare. So stop share. But then this thing keeps like beeping at me. So like someone just raised their hand, and then like there's a Q&A thing or whatever.
Yeah, if you, I don't know that we can unmute folks. So if you have a question, if you'll just type that into the Q&A, then we can answer those questions as they come in.
So the Q&A, I'm not seeing anything meaningful in the Q&A.
Yeah, no.
All right.
why don't you keep going with what you were, first of all, when you were talking about the statistics, Rob, so you say the conventional wisdom of your industry has been that they think that bankruptcies are going to take off at some point. I imagine it seems like that's probably somewhat, a lot of it depends on what happens with political environment and, and far as what's going to happen or.
It does. I definitely agree. And so depending on who gets elected and if the House and the Senate flips, either way, I mean, if there's a bunch of government aid and government money coming in the system, then I don't think bankruptcy is going to go up. I mean, because if the government's paying your bills, you don't need to file a bankruptcy. One thing, though, which would absolutely increase bankruptcy filings would be the student loans. I mean, there is some recent case law as to discharging student loans in bankruptcy, and favorable for people who want to discharge student loans in bankruptcy. And then I will tell you that there has been a bill pending in Congress, I don't know, for at least 8 years, if not longer, to allow student loans to be discharged in bankruptcy, in full, federal or private loans. And so that it's mainly backed by Democrats. And so if a Democrat's elected and then there's a Democrat, House and Senate, I mean, I think it's an Elizabeth Warren type bill, and so, but yeah, look, I mean, that's probably on the agenda. And so I will tell you what, I mean, I get at least one or two emails a day for saying, hey, I don't have any other debt. I need to discharge my student loans. What can you do? I mean, there's so much student loan debt out there. That's dischargeable bankruptcy. I mean, my graph, it doesn't matter anymore. It's gonna blow up as far as bankruptcies.
So you were saying that bankruptcy is a lagging indicator. I mean, how long does it usually lag? Is it a year? Is it 6 months? Is it 3 months? I mean, because maybe, pending what happens after the election, is there some predictability at that point once you know who's going to do what, or what are your, and I know I'm putting you on the spot, but I'm just kind of curious as to what your sense of it is. Not that I'm trying to hold you to it.
Yeah, I mean, I would say if you just look at the last two crashes, right? You know, then those were market crashes. I mean, this crash, I think, is more, I don't want to say artificial, but I don't think it was because the market was unhealthy, like the tech bubble burst or the real estate, like mortgage market 2007, 2008. So maybe that has an impact, and maybe I'm dipping my toe into like economic waters that I have no business like ever being in, but just like based on experience, you know, the 99, 2000 tech bubble, it peaked like around 2002, 2001-ish. And then we got 2 years later from this '08 burst. So, I mean, it probably picks up next year and then peaks in 2022, 2023, and it goes from there. I mean, that's just kind of historically what it was. Yeah. What else you got? You want me to do some of these questions or just want to wait?
Well, I think there's a couple on here that I think, well, you should probably be able to answer better than me. So one is, if a real estate agent has to file bankruptcy, does that affect their real estate licensure?
No, that has no impact on it whatsoever. It doesn't affect her. Well, yeah, someone already answered that. That's great. Do BK trends go somewhat hand in hand with divorces, and where are divorce levels post-COVID? I don't know where did it go? It just
Jill just
Oh,
answered it for you.
Dismissed it.
Yeah.
Well, I'm going to click the answer tab and see if it's over there now. So yeah, so I don't know where the divorce levels are. You know, we do a little bit of family law here, and I will tell you it's picked up a little bit, but I think probably all those same articles that everyone else read, you know, about, hey, you're stuck with your family and like divorces are going to come kind of thing. You know, I suspect though that's not a big driver of divorce. I think, like, you know, generally speaking, like if you can't stand being with the person, like an extra 8 hours a day is, I mean, surely it's going to that's going to hurt, but you're not going to want to be with them anyway. So that divorce already would have been happening or occurred. I think what's more likely to cause an increase in divorces is the money issues and all the problems that causes. So when one person loses their job, or I mean, that just when you're stressed with money, it impacts everything. I mean, it's just your fuse is much shorter and you blow up. But that's the kind of thing that's going to impact divorces and COVID, I think, not the whole like having to stay with your loved ones for, you know, hours on a day. You know, I saw a comment, I don't know where it was, about equity in houses. And that is actually something I think would also potentially impact bankruptcy filings going forward, because one of the reasons why I think we had so many filings back in 2010, 2011 is because, I mean, there's no equity in houses. And then, it was made worse because people are doing 120% mortgages and things like that, you know. You do that, plus, you know, the house goes way down. So people would be stuck, right? Like they couldn't move, they couldn't sell their house and, you know, move across the country, and they didn't have the mobility they used to have to find new work and otherwise kind of get new jobs. Now I suspect that, you know, especially because rates are going to stay low for a long time. I mean, I just read something recently, and I'm sure you guys are much more updated on this than I am, but I mean, I just read something that says that the Fed all the signs are going to stay at low interest rates for a very long time, which sucks for savers. So I'm kind of a saver, by the way, so it's sort of annoying for that purposes. But if people can just get second mortgages and they can refinance this equity, people will do anything they can to not file bankruptcy. And that might be a good idea if you want to get a second mortgage, but, you know, one thing that always just kills me that people, you know, they'll refinance, they'll convert a bunch of unsecured dischargeable debt in a bankruptcy. They'll convert that to a secured second mortgage, a secured HELOC or something like that. And then that debt, they have to pay that if they have to file bankruptcy later. So it's on the table for some people, and it's a good idea for some people, but it's just crummy when it happens. So yeah, I went to questions. I lost my train of thought there. What do you want me to?
Yeah, if you want to answer some of these, I I'm not sure what the question is here with what is the situation with unpaid back rent. I mean, obviously, if there's back rent that's not paid, that's potentially dischargeable in bankruptcy if there's other debts, I imagine.
Probably evictions. The question is probably, is there still an eviction moratorium? I don't know the answer, but that's probably what the question is. It's probably still out there. Because I haven't seen a lot of evictions. You keep also reading articles about the eviction crisis coming up, which, by the way, I mean, you call it an eviction crisis, I guess, but that's just because no one's been able to be evicted for the last 6 months, and so it's just unfair to look at that spike in evictions. But some of that spike will be due to people who couldn't pay the mortgage.
Is back rent dischargeable in bankruptcy, Rob? I mean, is that part of the debts if they get to a certain point that they could discharge?
Oh yeah. That is absolutely a dischargeable debt. And then if people go bankruptcy, do they generally get to keep their primary home? The answer is yes, only because they've talked to a lawyer. If they weren't going to be able to keep their house, then they won't file bankruptcy. They'll figure out some other option, like debt settlement, for example. And so so I guess I can segue into a little bit of like some very, very basics. The way bankruptcy works. Let me open up and Damian, I gotta run at 3. I have a phone call at 3. Is that
That's okay? Fine. We'll let you go.
Yeah, you can just take over. I'll send you my outline.
Oh, good. I'm sure I know a lot about bankruptcy.
Here, save as I'm trying to create a new PDF file here. File, save as PDF. And I want to share my screen because that'll actually be very helpful. So share screen. I hit doc 2. Okay, so can you see my screen?
Yes.
Okay, so the way bankruptcy works is, I got that.
Oh my gosh, you're gonna like draw and everything?
Oh yeah, I mean this is the most effective way to explain how this works. So here's a person, right? That's you. So when you're filing bankruptcy, so whenever a bankruptcy is filed, all of that person's assets, it goes into a bankruptcy estate, like this, right? So there's an estate, and so there's a trustee appointed, and that's what I do down south, right? There's a trustee appointed, and there's 2 types of assets. There's exempt assets. This is the long way of like answering the question: do you keep your house in bankruptcy? And then there's non-exempt assets. But this is helpful for people. Then I want to like spend at least 10 minutes on like some fun hypotheticals. But so the trustee can go into the bankruptcy estate. They are not allowed to take exempt assets, but they can take non-exempt assets. And the trustee doesn't want the assets, I can assure you. Once I had a case where there were a bunch of chinchillas. And I don't know if you guys know what a chinchilla is. I didn't. They're kind of like a hedgehog, but they're more rare and they're harder to breed and stuff like that. And I mean, they're worth a lot of money. And so I was like, if it eats, it's not an asset, generally speaking, but these things might have been an asset because they didn't eat a whole lot and they eat like lettuce or something. And so it's not that expensive to maintain them. So I was trying to take them and bring them home and put them in the basement and let the kids play with them and stuff. So, but like, I don't want the asset. I just want the money, right? Unless it's like gold bullion, I don't care. I could really care less. And so the trustee gets the money. That money then goes to creditors. And it's all, it's pro rata. And there's classes of creditors as well. So IRS and government debts and child support, they all get first dibs. And then in exchange for that happening, the person gets a discharge. And so, well, that's a bad box. So you get a discharge of your debts, right? And the discharge is what you're trying to get when you file bankruptcy. So you get a discharge. Now there's certain exceptions to the discharge, like fraud, theft, child support, I don't know, like willful injury, some taxes. I mean, there's a lot. I mean, I'm not going to do them all, but there's a lot of them. But that's why when you ask, is back rent dischargeable, like, is it in this list of things that aren't dischargeable? Then the answer is yes, it's dischargeable, right? So here's how this works though with the house. Like, like, I'm gonna do like a little call out here over here. So like, say you've got a house, right? That's a pretty good house.
I can't believe you're drawing. This is awesome.
I mean,
Maybe we
look,
should send this out to everybody at the conclusion of this because it's
I mean,
really good.
well, I don't know about that. That's a copyright mark if you couldn't tell. All right. So.
Oh, okay.
So basically, so say you've got a house, right? The house is worth $500,000, right? Value, and then you have, and then the note on the house is let's say 400,000. So then equals 100K of gross equity. Now, that obviously doesn't have cost of sale, right? Gross equity. So, right, so if this person files bankruptcy, what's going to happen is the exemption for someone who's under the age of 60 is $75,000. And then what would happen in this hypothetical, 25K is non-exempt. And so in this instance, the house would be sold by the trustee. This goes to this guy. And
The 75,000.
Yeah, because that's the exempt amount. And then this amount goes to the creditors. And if that pays off all the debts, great. If it pays off 5%, no one cares, right? And so the answer to the question is, why do most people get to keep their house? Is because let's say we have this fact pattern here. Well, reality is a bit different, right? Because reality might be, well, there's cost of sale. On a sale of $500,000 house, that 25K is pretty much going to be, I mean, the net sheet on this one is going to be something less than probably 75K.
That's because my brokers need to be paid. Just
exactly
so we're
right.
clear.
Yeah, that's exactly right. And so the net sheet's going to be less. And so if this person files bankruptcy, the actual amount that would be available to creditors would be something less. And if you're over the age of 60, the homestead exemption is $105,000. So this is pretty much how that's how bankruptcy works in a nutshell. Like for example, like a car, right? Like here's a car.
And to be clear, when you say exemption, we're talking the homestead exemption because most brokers have heard that term before.
Right, and so there's exemptions for different categories. So the exemption for a car is $7,500 under the age of 60, right? And so the way that works, it's the same kind of math. Like let's say you have your Toyota Sequoia. You have a note on it for $50,000, but it's worth 30. It's underwater. You're not going to lose the car in bankruptcy because there's nothing to take, right? The only time they would take that is if the trustee could sell it. The trustee still has to give $7,500. If there's money after that, that's when you would lose the car. And also too, if there's any other ancillary questions, like people ask like household goods, stuff like that, nobody cares about household goods. They're not worth anything. I mean, I guess, oh my goodness, the former Nuggets coach in the 80s, was it Dan something?
Doug Moe?
No, I don't know. Anyways.
Dan Issel?
Issel. It was Issel. Issel filed bankruptcy. And he lost a lot of household goods. But he had like a 10,000 square foot house with a lot of like really nice household goods. Like no one wants to buy household goods, I can assure you. And like, so, all right. So that's basically how bankruptcy works. And I've been off of let me stop the share.
I'll say you got to leave this up. That car is incredible. You should be a host.
It really is. It really is. It's the car of the future, Damian. It's the car of the future.
We need to flesh out the little Damian at the top. Put some like little spikies for the hair.
Right, that's funny.
Goatee.
Hey, before you leave this though, Rob, I want to. There was a question that came in, and I think it's important. So we got this guy who files bankruptcy. Can you talk about what happens for the bankruptcy? Because a lot of people end up working with a client, and I want to talk about what happens when the client has already filed bankruptcy, or is that maybe where you were going with this?
Yeah, no, thank you for leading that in, because this could easily take another. I'm stopping the share, right? Stopping the share. I know.
Well, I think I got a lot of real estate brokers here that want to know, what do you do if the guy's already taken bankruptcy? What do you do if they try to take bankruptcy during the course of a sale, during the course of a listing? What kind of approvals need to take place? Can you kind of walk through, from a broker's perspective, what that looks like?
Yeah, no, that's fine, and that was definitely kind of probably what we should have started with, but I got sidetracked.
But then we wouldn't have got to see your car. And
That's true, and that's valuable. That was a valuable piece of learning there. Right. So the answer to your question is like all law school fact patterns is the answer is it depends, right? And so a couple of key concepts you brought up and the key concept that you need to be aware of is something called the automatic stay. And I know that you're aware of that, but like a stay is a legal term for like pause, right? Like the governor literally staying somebody's execution, right? It's a pause. And so when a bankruptcy is filed, there's something known as an automatic stay. And it's called the automatic stay because it's automatic upon the bankruptcy filing. So to give you for example, like how powerful the automatic stay is, because it's federal, so it supersedes anything state law. Let's say someone's house was set to be foreclosed at 9 a.m. A bankruptcy was filed at 8:59 a.m. And then it's foreclosed? No, it's not foreclosed. I mean, it's void as a matter of law. Same thing for evictions. Let's say there's a court date and the judge says, oh, you lose. But right before the judge like knocks the gavel down, like the bankruptcy's filed, well, that state court judge's gavel is meaningless, right? So it doesn't matter. So that's the automatic stay. So the automatic stay, basically it takes all of the debtor's assets and it protects them. So no one can do anything with the debtor's assets when there's an open bankruptcy, unless you get relief from the automatic stay. So it depends on the fact pattern. So I put together a couple fact patterns, right? So, and I want to maybe pose this to you, Damian. So you represent buyer, or maybe one of your clients does. Right before closing, you discover that seller is in the middle of a bankruptcy. What do you do? Can you still close?
it depends on whether or not the trustee has released it from the estate.
Well, that's partially true. And so it depends on a ton of different factors. And so the first thing to do is to open up Pacer and then to see what kind of bankruptcy it is, to figure out if it's been released from the bankruptcy estate, to see if a discharge is entered, but to see if the case is closed, but just figure it out, because here's the biggest problem with the automatic stay is that if you violate the automatic stay, not only is the sale void, right? Like the sale didn't legally happen. I know people sat down title and signed a bunch of documents and money may have transferred hands, but title didn't change hands. But also if you have knowledge of the bankruptcy and you go ahead and act in contravention of the bankruptcy, then you're liable for damages. And it can be willful and treble damages and punitives.
So let's take your situation. Let me ask you this, because brokers don't have access to Pacer. In fact, they probably don't even know what Pacer is. Can you talk about, from a practical standpoint, how does a buyer broker deal with that? I mean, my thought would be to tell the seller, contact their bankruptcy attorney and get something from their bankruptcy attorney, get the title company involved and make sure that they're looking at this stuff. But you've been a trustee. What's your perspective?
Yeah, I mean, it depends how motivated. So we're talking about buyer's agent, right? It depends how motivated buyer's agent is. But if I was buyer's agent, I would probably call seller's agent and say, look, there's a bankruptcy filed. We need to talk to the bankruptcy attorney. And I would call the seller's bankruptcy attorney and figure out what's going on in the case. And you ask that person, can a bankruptcy be filed? That potentially insulates the broker for some liability, but there's also a bigger problem though, is that I can tell you that title doesn't particularly like to see open bankruptcies. So
Bill says no.
So, and this happens so often, is that let's say there's an open bankruptcy, by operation of law, that there is no automatic stay. So no one's ever going to get in trouble. And maybe there's some other ancillary things going on in the bankruptcy. The house is gone from the bankruptcy, but there's nothing from the judge that says the house is gone. It's just by a creature of law. What's going to happen is you're going to get a week before closing. Title's going to do their final search. They're going to find this open bankruptcy, and I'm going to get on the phone with title and say, look, no, by law, you can sell this. See, this is what the statute says, and this happened. And they're going to say, well, do you have an order from a judge? And we'll say, well, no, but it doesn't matter because the law says this. Title will say, yeah, I don't understand that. Do you have something signed from the judge? And then we're going to go back and forth, and title just is not going to insure, and the underwriters aren't going to do anything unless there's a specific order from a judge abandoning the property. And so getting back to that buyer calling seller, and then you call the bankruptcy attorney, the seller's bankruptcy attorney, you can sort of rely on that person, but I think the best follow-up question should be, should we file a motion to abandon? Do we need to get a court order here? Because I guarantee you what's going to happen. Title's going to find it, and then it's not going to close, and you're going to find out a week before. So it's
and they typically do require that order to abandon, and it'd be nice to talk to the title company, find out what they're going to ask for first time.
Well, that's also another point. So getting into kind of the trees for that forest of abandonment, if you will, like what I will typically do if I'm representing a debtor and this happens. So say like in this fact pattern, like I'm the seller's bankruptcy attorney, I will draft a motion to abandon, and I'll send it to my guy and say, email this draft version to title and have title sign off on this one before I file it with the court. Because the last thing I want to do is file something I think is just fine, but then title says, no, I don't like it, and so they have to do it all again. It just delays closing, people lock in good rates, and now those rates are gone kind of thing, so I don't know. So it's a real pain in the neck.
Well, and this is the other point, is that if you represent the buyer, not all bankruptcy attorneys are the same. There's a lot of them that say, hey, that's what the statute says, we don't need to do anything. Tell the title company they're stupid, and then you're still stuck because title company's not going to take the risk.
That's so true. That's so true. Like say, like the debtor's lawyer doesn't want to deal with it. Like, no, the title's stupid. Title should just do it, right? And that's not the answer. You can still do something, right? I mean, the inquiry doesn't end there. Like something can be done to mollify title. I have a question for you though. What if you know about the bankruptcy, and this actually is kind of a question for you. I don't really know the answer to. What if everyone in the room knows about the bankruptcy except for title? Are there any like ethical duties for realtors to like bring this up, or is that in contravention of their interest? Because like you're sitting down at closing table and you say to the closer, hey, you guys found that bankruptcy, right? That could totally kill the deal. Almost certainly.
I'm fairly certain that title would come back to the brokers and or the clients saying that you did not tell us everything that was pertinent to this transaction. And frankly, withholding information to me sounds like a fraud when you know that it would be something that would affect the deal. It's going to screw it up and you don't tell them that doesn't feel good. So,
yeah, it doesn't feel good, but what happens if the realtor doesn't know? Like what happens, or the realtor called the lawyer and the debtor's lawyer was one of these mill shops, which as we all know I am not, but called one of these mill shops, and the lawyer's like, no, it's good, you can close, right? Does that the mens rea, right? The mindset changes. Like, so you're not necessarily, doesn't smell so bad anymore.
I will tell all of my brokers, tell title, make sure that they're going to insure this, because I just see where this turns into a big mess later on. But you're right. And frankly, it's probably no harm, no foul, because the statute is what the statute is if the guy says it. But if that's the case, then tell title, and title should be able to fix it. But we have this problem come up all the time. And, the stay is a problem. We've had clients that decide in the midst of a transaction that would be a good time to file bankruptcy before they get their money, because then they can just keep their money, or at least that's the mentality of it. And, obviously, what would be your advice if that happens?
Right. And so, well, first of all, just know that the listing agreement that you signed, like, so let's say it's your client that files the bankruptcy, that listing agreement is now void. So I know you may have had the exclusive right to list for 9 months or whatever the term was, but if they file bankruptcy in month 4, that listing agreement is void. And so, even if the person can totally be a jerk and screw over the realtor and sell the house and just take all the realtor's hard work. And I'm sure that happens, right? It probably doesn't happen that often. I'm sure it happens. But I think a good practice would be, if someone does file a bankruptcy, after they've signed that listing agreement, and they still want to work with you, they need to execute a new listing agreement because that pre-bankruptcy obligations are discharged, but post-bankruptcy obligations are not discharged. And so you would have a new listing agreement that's post-bankruptcy, just so you can still kind of CYA and make sure you have all the protections in the agreement. That's one thing to consider.
And real quick, we have Terry Williams weighing in, which happens to be the underwriter for Heritage. So he says, Rob, from a title insurance standpoint, oftentimes a seller will have a judgment that was not avoided by the court and survived the bankruptcy and still attached to the property. We then make a requirement for it to be avoided, which makes that they need to reopen the BK, and that often time delays the closing. Why are judgments not typically avoided in a BK?
You know, that is a question best answered with a graphic.
Oh, good.
So we will go back to that. Can you see my screen?
Yes.
Yeah. Yes,
Okay.
I can see your car again. That's awesome.
All right, so this is a call out, right? So the answer to that question, and that is so common, right? I mean, we even have that in our fee agreement with our clients saying, listen, we don't pull public records or do O&Es on properties because if there's a lien on there and you don't tell us about it, it's not going to go away in the bankruptcy. So here's the thing. So here's a debt, right? A judgment lien, right? The debt attaches to the house. Oof, that's a big house, a ranch. And the debt attaches to the person, right? So whenever a bankruptcy is filed, this link is broken. A bankruptcy does not impact a separate lien. So the debt is still, the debtor, the person no longer owes the debt, but the house is still obligated on the debt.
But you have an appointment soon.
Did you hear that too?
Yes, I hear you have an appointment soon.
That was my my system. If I don't turn it off, it's gonna, I don't know how, it's gonna keep interrupting. It's nice British accent though. It's very, very peaceful. So yeah, I got like 9 minutes before I jump on this call, but
Okay.
so yeah, so the answer is the reason why is because the discharge only eliminates this liability. It doesn't eliminate the lien liability on the actual real property. Does that make sense?
Yeah.
All right.
Unless you scrub it, there's this extra process for it.
That's right. So there's an extra process. So you can file. I'll stop sharing now. You can do a motion to avoid a judgment lien, and the certain circumstances have to be met, meaning you have to have less than $75,000 of equity in the house, and if you do, you can void judgment liens. You can void judgment liens, and so, but oftentimes what will happen is someone will have a lien on their house, they'll file a bankruptcy, then they want to refinance, for example, then there's a judgment lien just still sitting there, and so then a bankruptcy is going to have to be reopened to void that judgment lien. And so, and the equity, the math is determined as of the day the case was filed. So fortunately, you don't have to use the post-petition equity, particularly 50 years later.
I got a couple quick ones, Rob, I'm going to ask because they're questions here, and I know you got to get going. But so if you are asked to sell a house while the owners are currently in bankruptcy, the questions you should be asking is, you should be talking to their bankruptcy attorney and making sure that it's been abandoned, and then asking about this order also because it may be a problem with title. Is that correct?
Yeah. I mean, yes. I mean, title, if there's an open case, I mean, listen, the title guy, I'm sure, can answer this question, but in my experience, even if there's a discharge, but if there's an open bankruptcy case, like even if there's like the trustee has to file some taxes and the debtor's long gone, or it doesn't matter, there's an open bankruptcy case, and title just is not going to deal with that. Like they want an order signed from the judge. Like this is the way it's going to be.
Another question, does the voiding of the exclusive right to sell or the listing contract occur at the time of the filing or discharge? And it happens at the time of filing, correct?
Right. So that's a trick question because the answer is, the technical answer is that it's voided at the time of the discharge, but all debts that all debts and obligations owing at the time of the filing are voided at the time of the discharge. So in theory, you could have someone, they could file bankruptcy on day 1, day 15, they could sign a new contract, then day 90, they can get a discharge. That discharge wouldn't impact that day 15 post-bankruptcy new listing agreement.
But the one that if they filed it, that one's going to get discharged. So you're better off signing a new one after the bankruptcy has been filed.
Yes.
Correct? Okay.
Yes. Yeah, absolutely. Yeah, you should. You should. I mean, because there's lots of important things in those contracts for realtors.
Let's see. Is there a way agents can see the liens? Is that there's really no way they can see other than Pacer.
Oh no! So what I do, if an agent is like an on-the-ball type of individual, like be more on the ball than me, but you can order. We order O&Es, and then title companies. We have and I don't want to say like the wrong title company here, Jill, but we have an account with the title company. We pay $5 and we get an O&E. Ownership and encumbrances report is what that is, and then you get them pretty fast. That will show the consensual and non-consensual, i.e. the judgment liens on the property. Now it's only 90% accurate. I've seen some O&Es that will miss judgment liens because they're not guaranteed because they cost $5, but that's good enough for us. But I, of course, have the client's initial saying these are 100% accurate,
So I think that covers most of this. Do you have anything else, parting words you want to give us on bankruptcy?
My very informal math at one point in the past indicated that 1 in 6 people in Colorado has filed for bankruptcy. And so, which is a lot more than people expect, but that's just because no one really wants to talk about it, which by the way makes it a little bit harder to get business. Like if you have a great realtor, someone's gonna be like, oh, my realtor is great, let me give you their card. No one's gonna say, oh, my bankruptcy attorney, best guy in the world, he drew this great picture, explained it so well, let me tell you how awesome he was. Like no one does that. So it's hard to.
I will tell you, brokers tend to get people to tell them their real financial pictures, so those are the ones that tend to get sellers rely on, or buyers.
That's true. No, I agree. Yeah. So a couple of, we can push at the very end here. So we got.
Well, bankruptcy. Somebody just wanted to know who are the players in bankruptcy, and then I have another question about. Can you give a rundown as to what Pacer is?
Pacer. I don't know what the acronym is, but here I can probably go to it really fast. Like
draw it. Do you want to draw it?
Yeah, I should. I really should, because that would probably be the way to go. All right, so you can see my website. So this is the bankruptcy court website. It's just on one of my tabs, right here. Just right there, a link. You click this link. You go to Pacer, and like the public access. And actually, you can get an account for free, I think. And you get up to like each document you click is like 8 cents a document. But you can get on here. You can get on Pacer, and then you can search up by social if they filed bankruptcy, and you can look into their case. So that's what Pacer is: public access to court electronic records. That's what it is. So it's a way to look at the court records. That's what Pacer is. And so just by reference, it's right there on the bankruptcy court website.
So real quickly, you want to run down who the players are in bankruptcy?
Yeah, no. So there's the debtor, the person that owes the money. There are the creditors, the persons that the people that the money are owed to. There's the bankruptcy trustee, and that's the person who administers the estate and distributes money to the creditors. And then there's the judge. And so it's similar to regular litigation. Regular litigation, you have the plaintiff, the defendant, and the judge. In bankruptcy, you kind of have the debtor, the creditors, the trustee, and the judge. Those are the players.
So the last one I'm going to ask you, this is a disclosure question, And so somebody asked, should there be additional provisions that buyer agents put in their contracts that says seller certifies seller has not filed bankruptcy in the last 12 months or isn't in the process of filing bankruptcy? I have my own opinions of it because I don't think it matters or is effective, because if they do it, there's no violation. So, because bankruptcy is a different beast, right? I mean, this is a...
Yeah, so it's kind of like I like the tenor of that question. I mean, like you can't put ipso facto clauses in bankruptcy. Like I won't file bankruptcy in the middle of this. Like you can't do that. Like those are void, or this debt is not discharged in bankruptcy. Those are ipso facto clauses, and those are just void as by matter of law, because then everyone would put them in their contracts, and bankruptcy wouldn't mean anything. But for this purposes, seller certifies has not filed bankruptcy in the last 12 months. I mean, that could be a little CYA kind of thing. I mean, does that protect the broker? I mean, maybe put that in the additional provisions of the real estate contract somewhere. I don't know. I mean, I don't know that it would be worth it, but you could do it. I don't think it would hurt. I don't know. You tell me.
My concern is it, okay, so it says they're not going to, or it's not in the process or whatever, and then they decide to file it, you're still in the same position. So to me, it's, somebody's going to have to check and make sure that bankruptcy has or hasn't been filed. It doesn't necessarily negate the impact of a bankruptcy on the buyer.
Yeah. All right, well, what else, man? Anything else?
It's 3:00.
Yeah, the phone's ringing, and so I don't know if it's my guy.
Why don't you go take that, and Jill can answer the questions about copies of this recording and all that good stuff. But
okay,
thanks so much for your time.
Yeah, it's my guy. All right, thank you. We'll see you.
Thanks, Rob.
Yeah.
Really appreciate it.
Yeah, any questions? I'm serious. Like, even if it takes 5-10 minutes, I'm always happy to chat with people, because I mean, God only knows that I call people all day long, and what goes around comes around. So like, that's like good karma. Golden rule kind of thing.
Appreciate you paying it forward. So we'll make sure everybody has your contact information. So
okay, see ya.
bye, Rob. Thanks,
Bye,
everybody,
Rob,
for joining us. And yes, we are recording today, and I'm going to email that out, the link to the recording out to everybody, along with some of the additional items that we talked about. I'll send out the link that Damian shared as well, with the different counties, the map of the counties, and what level they're currently on. And whenever we sign off here, you should get redirected to a registration page for November's industry update, again with Deanne Stodden. So go ahead and register for that so you don't forget about it. And we'll look forward to seeing you on November 5th. Thanks so much for joining us today. Appreciate having you on.
Hi, guys.